Good afternoon, ladies and gentlemen, and welcome to the Americans with Disability Act Amendments of 2009 conference call. At this time, all participants are in a listen-only mode and will remain so for the duration of today's conference. Please note that the call is being recorded. I will now like to turn the call over to your host, Dr. Natalie Harnbaum. Ms. Harnbaum, you may begin.
Okay, thank you. Good morning, everybody, or good afternoon, depending on where you are. Just a few housekeeping items first. The agenda for today is about 40 minutes of lecture, followed by approximately 15 minutes for questions and answers at the end. There is 1 hour of CME and MOC credit for this program. Prior to the session, you received a verification form with instructions, or you can follow the link that was in that instructions. No certificates will be sent, but the transcript of this and other ACOEM educational programs can be viewed and printed from the ACOEM website. Members and non-members can both view their transcript directly from the website. During this program, we will be accepting questions electronically, and on the screen you can see how to open the question box in order to submit your questions. This is also in the PDF file of handouts which you received with the instructions. We will address questions as time permits and suggest that you submit your questions early for consideration. If you are participating via audio over your computer and need technical assistance, please refer to the bottom of your instructions, or if you phoned in to reach an operator, dial L. We'll have two speakers this morning. The first is Margaret A. McCausland. Peggy McCausland opened her office, the law offices of Margaret A. McCausland, LLC, in June 2006, and her focus is on representing employers. Prior to opening her own firm, she was a partner at Blank Rome LLP and served as adjunct faculty at the Villanova Law School since 1999. She obtained her law degree cum laude from Villanova University School of Law and has served as staff member and the business editor of the Law Review. Prior to law school, she obtained her BS from St. Joseph's University College, where she attended for 7 years. She has been voted as a Pennsylvania super lawyer the last 5 years running, and was also named as one of Pennsylvania's top 50 women super lawyers. The second speaker is Dr. James Tachi. Dr. Tachi is Manager of Medical Health and Wellness Services for Xerox Corporation. As a member of the Xerox Environment, Health, and Safety Organization within Xerox Corporate Operations, he works to ensure the continued safety, health, and productivity of Xerox employees and supports Xerox operations globally. He also holds part-time teaching appointments at the University of Rochester Medical Center and is board certified in both public health and general preventive medicine, as well as in occupational medicine. He is a fellow of the American College of Occupational and Environmental Medicine, as well as the American College of Preventive Medicine. Serves on governing boards at ACOEM, ACPM, and the American Journal of Preventive Medicine. He's licensed to practice medicine in New York and is also licensed to practice law in New York, Massachusetts, and the United States Supreme Court. And we will now go ahead and begin the session. Peggy?
Thank you, Natalie. One very quick comment. It took me 7 years because I was working full-time during the day. It wasn't that I was just slow. So with that said, let's take a look at what's been happening to the Americans with Disabilities Act. The legislation that started all this was signed now on September 25th, 2008. It becomes effective on January 1, 2009. What that means is that if a decision regarding an individual was actually made on December 31st of 2008, the old ADA statute applies. This will apply to requests for accommodations that are made on or after January 1, 2009, or will apply to decisions regarding an individual that are made on January 1, 2009 or after. What the new amendments did was, in essence, they rejected the Supreme Court decisions that had narrowly construed the Americans with Disabilities Act over the last several years. Two of those primary decisions were the Sutton versus United Airlines, which was passed back in 1999 and talked about mitigating measures, and then in 2002, the Toyota Manufacturing versus Williams case. Now, they did not, in fact, change the definition of disabled in the statute. We're going to talk about that in a minute. What it was before and what it is now remains the same. A person is defined as disabled if they have a physical impairment Oh, I'm sorry, I'm pressing the wrong arrow. Okay. A physical or mental impairment that substantially limits one or more major life activities, if they have a record of such an impairment, or if they're being regarded as having such an impairment. So that's what the statute said before. That's what the statute still says. But after Sutton, the way the statutory language was interpreted was that an impairment was considered not to substantially limit a major life activity if it was being corrected by mitigating measures. So basically the courts had taken the position that you had to look at corrective measures when deciding whether or not someone was disabled, and you had to look at both the positive and the negative aspects of the mitigating measures. So you would take into account such things as whether diabetes was controlled, whether high blood pressure was controlled by medication when you were looking to see whether or not the person was substantially limited in that major life activity. And if the impairment did not substantially limit a major life activity once corrected by mitigating measures, then in effect the person was not disabled under the Americans with Disabilities Act. Now, after the Toyota decision, the impairment also had to prevent an employee from performing tasks that were important to daily life. They would look at manual tasks that were unique to a particular job, not necessarily important parts of most people's lives. Somebody had to be viewed as unable to perform normal household chores, bathing, brushing one's teeth, among the types of manual tasks that were of central importance to people's lives. In summary, if you had to be unable to perform or be severely restricted in performing certain activities, and it had to be more than just one activity. It had to be something that you couldn't do something or were severely restricted in doing something that somebody in the general population could perform, and you had to be severely restricted in the manner and condition and duration of how you perform those activities. The result of the Sutton and Toyota decisions were that because the courts had applied this very strict standard, this demanding standard, when determining whether an individual was sufficiently disabled to be covered by the ADA, what you found, this actually came as something of a surprise to me because I represent employers and I feel like they were constantly on the defense on ADA issues, but the statistics said that 90% of ADA lawsuits failed. So that things like, carpal tunnel that did not limit a person's ability to perform household tasks, or myopia that was corrected by lenses, or high blood pressure that was controlled by medication, those things did not, in fact, qualify as disabilities under the ADA. Now, my own experiences was that most employers were much more conservative than that in any event because they knew that it was an expensive proposition to defend such cases even if they might ultimately win. And so they did, in fact, tend to be rather conservative in their approach with their employees and tried to provide reasonable accommodations even when they felt that maybe technically things weren't going to qualify under the statute. But at least prior to these new amendments, if they wanted to wage the battle, they would likely win it, and it was a little less likely that the battle might be waged because what plaintiff's employer wanted to take on what they knew might be a losing case. Now the amendments come into place, and what Congress basically has said is that they thought those court decisions were way too narrow, that they set a standard that Congress had never really intended to set and made it much more difficult for people to bring claims under the ADA than the original legislation had intended. I'm frankly a little surprised by that because I actually thought that people were bringing cases that were much broader than what I thought Congress initially intended, but that's not the way Congress sees it. So what changes have they made? Well, they have specifically said in these amendments that a disability, the definition of disability, must be read broadly. The courts are now instructed to provide a broad scope of protection for employees. They need to provide coverage for employees, and this was the quote, to the maximum extent that's permitted by the statute. Some commentators looking at this since the amendments came out said, well, maybe we should look at it as a sliding scale. And if you looked at Toyota and you looked at Sutton, you might say that substantially limited was a 10 on a scale of 1 to 10. And that's what you would have, the threshold you would have had to meet to qualify for ADA protection. And that now it's probably shifted back to something like perhaps a 7 on a scale of 1 to 10. It can't just be a modest impairment of a life activity, but it certainly does not have to be a severe restriction. What else did they change? Well, they have changed the definition of major life activity. They included a specific list of activities, and many of the old ones, of course, remain on it, but the activities that you now see on the slide: performing manual tasks, caring for oneself. How general is that? Eating, reading, concentrating, working, sleeping, communicating, thinking. And then the old standards: seeing, hearing, walking, standing, lifting, bending. All of those are now considered major life activities. So now you're looking at an impairment that impacts on a major life activity, which is virtually anything you can conceive of, and does not have to severely restrict your ability to engage in that major life activity. Another change is that you only need to impact one of those major life activities. The Toyota case had specifically said working, for example, wasn't enough. It had to be working plus something else. Now, only one would be necessary to meet the standard. Now, the legislation did not mention driving. It did not specifically mention using a computer or heavy lifting. But the sense is that even though it may not be one of the activities specifically listed, the sense is that now those things, in fact, would be covered. It's only about a month or two, the 10th Circuit ruled against an employee, for example, who couldn't drive, saying that that wasn't enough. The feeling of many commentators is that if that same case were brought next year, the employee would win rather than the employer. They have also, under major life activity, included this list of major bodily functions. And if the impairment affects a major bodily function, then it's going to qualify as a disability. The immune system, cell growth, digestive functions, reproductive functions, neurological and brain functions. Others that are not specifically set out there, but would be digestive, bowel or bladder, respiratory, circulatory, endocrine. Excuse me. And there were, prior to this, there was sort of a divide in the courts. Some courts had already sort of gone in that direction and decided that, yes, bodily functions should be looked at, but some jurisdictions had said no. There was a dispute, for example, about reproductive. Someone who was, in fact, infertile and needed, as an accommodation, time to go and get their fertility treatments. Some courts said, well, no, that's not an impairment, that accommodation isn't needed. Now it would seem that that accommodation actually would likely have to be provided because reproductive functions are specifically listed. Another change was that mitigating measures must now be ignored. This is, I think, a really crucial change because before you could look at the fact that the person's diabetes was being controlled by medication or that their blood pressure was being controlled by medication. Now you can't look at those things. You have to ignore those mitigating measures. And except, with one exception, ordinary visual aids such as eyeglasses or contact lenses. Those are now the only mitigating measures that can be factored in when you're trying to decide whether or not an employee is in fact disabled. So somebody can be using medications, prosthetics, hearing aids, mobility devices. Maybe the hearing aid makes their hearing fine. That doesn't matter. You need to ignore those mitigations. Now, another sort of dangerous part in my mind is this regarded as prong. The employee is now regarded as disabled if they have been subjected to discrimination because of actual or perceived impairment, even if that impairment doesn't limit a major life activity. This will not be available only when this impairment lasts 6 months or less and is minor, and it has to be both. So it's got to be a minor impairment that lasts less than 6 months, and then the employee would not be able to use the regarded as prong. But in other circumstances, they will. So even if they don't have an actual impairment, if they, for example, an employer decided somebody had cancer and the employer decided that the job was too stressful and moved that employee to a different position that they thought was less stressful and better accommodated their disease, but it's not an accommodation that they want or sought, and they don't think that they are in fact disabled, well, they can wind up suing you for discrimination, saying that you kind of forced this change on them because you regarded them as disabled. It's going to be a pretty easy test to meet. And what you don't have to do for an employee that is in fact only regarded as disabled is you do not have to provide a reasonable accommodation. And that's something that has been sort of up in the air up to this point. It was not clear. Some jurisdictions viewed it one way, some another. Now it is clear that you don't have to actually provide the reasonable accommodation. The thinking being that someone who is only regarded as disabled, the real test was, or the real challenge, let's say, was the employer's attitude, not the actual impairment, because that wasn't an impairment that actually rose to a disability. So why would we provide an accommodation? We can pretty much expect, I mean, I'm not a plaintiff's lawyer, but if I were one, I would probably never file an ADA claim again where I didn't throw in, almost as a backup argument, the regarded as prong. So I will argue that the person, was disabled, but as a backup argument I'll have, and to the extent they weren't disabled, they were regarded as disabled. Another change is that, or a clarification at least, is that an impairment that's only episodic or is in remission is a disability if it would substantially limit a major life activity when it is active. So someone who has cancer, in fact, is in remission and they seem to be functioning perfectly well, is still covered now under the ADA, because if it weren't in remission, it would be likely impairing a major life activity. One bone that they threw to employers is that reverse discrimination claims are clearly now prohibited. That was not clear before, so that, for example, if you made an accommodation to a disabled employee, someone who is not disabled could not sue the employer, arguing that they were victimized by the fact that you showed preference to this disabled person. And they did keep the exclusions that were already in the ADA for transvestism or gender identity disorder, the psychological criminal conditions. Those are all still in there. Current use of illegal drugs, they didn't remove that. Now, they also specifically provided that the EEOC was to issue binding regulations and interpretive guidance to flesh out the statute. interestingly, just earlier this week, the EEOC failed to do so. They couldn't agree. They drafted some regulations, but they did not, in fact, agree on those regulations and therefore did not pass them. And so when this statute becomes effective on January 1, employers will be left to flesh it out themselves. The EEOC was specifically supposed to define the term substantially limits with this lower standard that the court, or that the Congress wanted the courts to apply. Employers are going to be kind of left to figure that out for themselves until the EEOC finally gets its act together and decides what it wants the regulations to say. What's clear is that employers have to start complying with this statute January 1. That has not changed. They're just not going to have the interpretive guidelines that might have made this a little easier. My advice would be to employers, make a good faith effort to apply the new standard absent the guidelines that will, I'm sure, come out at some point. I just don't know how long it's going to take. Kind of in summary, before we turn things over to Dr. Tachi, what steps do I think employers ought to take? Well, I'd say, review and revise your existing ADA policies, and some that maybe you don't even think of necessarily as ADA policies, but they certainly can impact or be impacted by the ADA. So if you have a telecommuting policy, for example, I'd say you want some constraints on it so that just anybody isn't necessarily in a position to say, well, you have to let me telecommute. You may, as an accommodation, find yourself agreeing to do it, but at least you don't want it totally unlimited. Or to the extent you have light duty policies, you want to take a look at them and make sure that they wouldn't come back to haunt you in the event that you wind up offering light duty as an accommodation under the ADA. And if you have an ADA policy specifically, in your handbooks or whatever, take a look at it, see how it reads, see if it would still seem consistent in light of the changes that have been made. I think, establish procedures to respond to requests for reasonable accommodations. My recommendation would be that, at least for the foreseeable future, I would suggest that you have a central decision maker. Don't be having individual supervisors deciding what kinds of accommodations to make, at least until we all sort of get a handle and we get as familiar with the new amendments as we've now become with the 1990 statute. That statute's been around a long time. People got accustomed to it and got comfortable with it, but the game has changed. And I don't think employers are really in a position to get all of their managers up to speed in time. So I think having a central person that's consulted about these matters makes a great deal of sense. I would establish procedures for documenting the interactive process. That process remains critical to avoiding ADA claims. Having procedures in place and that people understand what the interactive process is about and know how to implement it. I would revise your medical certification forms to be consistent with what it is that it seems that, if in fact you've used them, and not all companies do, but if you've had them, take a look at them and revise them as necessary. I would say make sure your job descriptions include essential functions. They always should have, but I know a lot of my clients just never seem to get around to reviewing the job descriptions or separating out essential and non-essential functions until a crisis arises, and then they take a look at it. I would say that ought to get on the to-do list. And include disability discrimination training programs and the other kinds of training programs that you do. This is certainly not one that I've typically seen. I do a lot of training. Employers are always asking me to do training on harassment avoidance. Everybody focuses on sexual harassment, and I think that for a period of time at least, disability discrimination training programs are going to be critical to employers not getting embroiled in expensive disability discrimination litigation. People need to understand some basic things like how important it is that they not talk to employees about going and getting help. It's always been my advice that you focus on job performance, not the reason for the job performance, but now I think it's critical because of the regarded as component is that much clearer, and if a supervisor doesn't realize that he or she shouldn't be talking about, I think you've got a drinking problem, or, I think your cancer is getting in the way, and don't just focus on the job, they're going to open the employer up to a regarded as claim. Supervisors need to learn not to seek too much information. They need to be reminded that they shouldn't be taking action because the person has an impairment as opposed to because the person's performance needs correction. And those are all things that don't automatically come naturally to supervisors. We probably should have been doing this kind of training for supervisors for years, but this is now a real incentive to put it on the radar screen and move it up to the top of the list. And with that, I'm going to turn it over to Dr. Tachi, who's going to look at some examples of the kinds of things that you may all struggle with in the months and years to come.
Thank you very much, Peggy. My name is Jim Tachi. I'm the Manager of Medical Health and Wellness Services for Xerox Corporation. Again, good morning or good afternoon, as the case may be, to everyone in the audience. Thanks very much to ACOEM for inviting me to speak today. And thank you also very much to Peggy McCausland for doing really what was the heavy lifting today by walking everyone through the regulatory changes. Natalie Hartenbaum mentioned in my introduction my various affiliations. I do have them listed here also as affiliations and disclosures. I've looked at them and I see no financial interest or other conflict of interest present either for me or any of the organizations there with whom I'm affiliated. But again, for the lawyers' sake, those are my disclosures. Also, for our attorneys' sakes, the opinions expressed by me today are purely my own. They're not those of Xerox, they're not those of the University of Rochester, nor are they of ACOEM's. I will say that in preparation for this talk, I took the new regulations or the soon to be implemented new laws actually, and went through the case scenarios, derived the case scenarios, presented them to various corporate attorneys, some here at Xerox, some at other employers, either current or past employers, just to get their thoughts on it. So the case scenarios and the answers today are sort of a constellation or a combination of the various opinions that I received. Some employers, Xerox being one of them, tend to be relatively accommodating with their approach to the Americans with Disabilities Act and with respect to employee accommodations in general. Other employers are perhaps less accommodating, or other folks that I've chatted with. So the opinions today are more of a blended view of those. What the talk is not, again, more legalese. It's not legal advice. It's not medical advice. Also, it has to be clear that it's not based on established case law or published interpretive guidance. The case law in question is actually, in large measure, case law that has been rejected by the Congress in these U.S. Supreme Court cases that they said were misinterpreted or misdecided. And as Peggy mentioned, the EEOC has been asked to provide interpretive guidance, and this week they specifically declined to do so, although folks will be anxiously awaiting that. And again, these are not the official positions of any of the institutions with whom I'm affiliated.
Jim, could you please speak up a bit?
Okay.
Thank you.
Is this better?
Yes, it is.
Okay, thanks, Natalie. And also, these are not reviews of actual cases. These are purely hypothetical. What the talk is a discussion about what appears to be the legislative intent of the ADAA, using some realistic but purely hypothetical cases. And again, they're purely hypothetical, and it's what we think is the legislative intent, and we don't have any actual interpretive guidance yet issued by the EEOC. As a general rule, I've tried to include either clinical or occupational details when they're pertinent with respect to the discussion and analysis of the case. Where the details are not particularly germane to arriving at a decision, I've tended to exclude them. I promise that I'm trying not to oversimplify the cases, but for presentation purposes, I felt that would be best. Certainly when we get to the Q&A portion of the discussion, I've seen the names on the participant list, many of whom are friends of mine. I'm sure that some unique and challenging scenarios may be posed at that time, and we certainly encourage that. Okay, our first case is a 45-year-old otherwise healthy male with well-controlled insulin-dependent diabetes. He works as a manufacturing employee, and he works in a non-safety sensitive capacity. He requests an accommodation under the ADA related to his diabetes. For purposes of this discussion, the specific accommodation is not necessarily germane, but the request could be accommodated without disrupting either existing seniority, collective bargaining agreements, or the essential business processes and essential job functions. However, it would require a deviation from the usual management or supervisory policy of his workplace. And the question becomes, is this individual afforded protection as an individual with a disability under the ADA? Well, under the, we'll call old ADA, and it's important to note that this is the old ADA after the Sutton case, or the Sutton triad of cases that Peggy mentioned earlier. The individual would not be afforded protection under the ADA because of the fact his diabetes mellitus was well controlled, and that fact would be considered a mitigating factor, and his impairment therefore would not be viewed as limiting a major life activity. Under the new ADA, or the ADAA 2008, rather cumbersome name for the act as an editorialization, the ameliorative effects of mitigating measures such as insulin should not be considered in determining whether an individual has an impairment that substantially limits a major life function, including the operation of major bodily functions. And this is a typo. The list that Peggy mentioned was several body functions and systems, so one might insert endocrine system instead of immune system here. But long and short of it, under the new ADA, or the ADAA, the mitigating effects of well-controlled diabetes through insulin would not take the person out of the realm of having protection as an individual with a disability. Our second case, a 45-year-old otherwise healthy male with 2200 uncorrected vision bilaterally, which corrects to 20/20. I have taken some clinical liberties, by the way, in these cases, just to illustrate the underlying points. With either eyeglasses or contact lenses, works as a manufacturing employee in a non-safety sensitive capacity. He requests an accommodation under the ADA. The request could be accommodated without disrupting existing seniority, collective bargaining agreements, or business processes and essential job functions. However, once again, it would require a deviation from usual management or supervisory policy. Is the employee afforded protection as an individual with a disability under the ADA? Once again, in this instance, his disability, which would affect his visual system, is mitigated by the use of either glasses or contact lenses. Well, in this instance, under the old ADA, again, post-Sutton, the individual, again, is not afforded protection because of the fact that his vision is easily corrected. This mitigating factor, with respect to his impairment, eliminates any substantial impairment of or limitation of his major life activities, and he's not considered an individual with or protected as an individual with a disability. Under the new ADA, or under the ADAA, the individual is still not afforded protection because of the mitigating factor. Slightly different. This is specifically because, as Peggy mentioned, under the ADAA, there is a specific exception made for ordinary eyeglasses or contact lenses with respect to the rule on mitigating measures. So Congress took the time to say you're not to consider mitigating measures as eliminating the effect on a major life activity, and therefore somebody's status as a protected individual under the ADA, except for eyeglasses and contact lenses. So there is that specific carve-out. Our third case, same gentleman. We have a 45-year-old otherwise healthy male, 2200 uncorrected vision bilaterally, which corrects to 20/20, either with eyeglasses or contact lenses. He has been denied employment in a job in which he would work in a safety-sensitive capacity because by federal regulation, the position that he was applying for requires at least 20/40 uncorrected vision, irrespective of the ability to correct with eyeglasses or contact lenses, because there is an inherent public safety risk associated with this job should the individual suddenly lose his eyeglasses or contacts and be unable to retrieve them. Is the employee afforded protection as an individual with a disability under the Americans with Disabilities Act, or of course under the ADAA, as we're discussing today? This example is loosely drawn actually from the Sutton triad of cases. One of those cases dealing with an airline pilot. Actually, I think they were sisters or something, or siblings that were airline pilots. But long and short of it, while their vision could be corrected, there was a supervening public safety interest that said, well, if in the course of flying one loses their eyeglasses or one loses a contact lens and is unable to see well enough in order to retrieve them and put them back on, there's an inherent public safety risk. In that case, the individual was not afforded protection. The rationale for not affording the individual protection, which was the point of controversy actually with the ADAA, was because of the fact that the vision was easily corrected and considered a mitigating factor, and therefore the impairment would not limit a major life activity. However, and perhaps more on point to the clinicians, especially the folks engaged in public safety, occupational medicine, the Sutton triad of cases showed a deference to federal regulatory authority to protect public safety and an employee's duty to adhere to such regulations. So there was not only the mitigating factor of being able to wear eyeglasses, removing the protection of the ADA, but in their commentary, the Supreme Court also again showed deference to federal regulatory authority to protect public safety. Under the ADAA, this individual is still not afforded protection, in part, as we said, because the eyeglasses and contact lenses are not considered as part of the mitigating factor exclusion, i.e., if somebody can wear eyeglasses or contact lenses to correct their vision, then that does in fact eliminate that as a impairment of the major life function. However, important with respect to the ADAA was that it was silent with respect to the regulations put in place to protect public safety. And it didn't address that component of the Sutton triad of cases where the court did talk about, be it OSHA or the FAA or the Department of Transportation, et cetera, those federal agencies vested with protecting public safety. What the ADAA did do was give the EEOC, the U.S. Attorney General, and the Secretary of the Department of Transportation the authority to issue regulations interpreting the definition of disability under the ADA. As Peggy mentioned earlier, the EEOC has specifically decided to defer on this charge, at least for the time being.
Jim, excuse me, can you try to finish up in the next 5 to 7 minutes? We want to leave a little bit of time for questions at the end.
Okay, Natalie, I'm going to start talking in Natalie Hartenbaum speed.
That's not nice.
Okay. All right, I will pick up the pace through the cases just to allow some more time make sure we allow time for questions. Case 4, we have a 58-year-old otherwise healthy female with early onset peripheral vascular disease. She experiences claudication when walking in excess of 2 miles or standing for longer than 2 hours consecutively. She works 4 10-hour shifts per week as a stock clerk in a big box store and frequently walks 4 to 5 miles per night per shift up and down the aisles labeling products. She may have to stand the entire time other than her regularly scheduled breaks, which occur every 2.5 hours. When she's assigned to the checkout aisle of her job, she may have to stand the entire time except for her regularly scheduled breaks, as noted, every 2.5 hours. She has less activity tolerance to this stationary standing than she does to walking. She has requested a reasonable accommodation of a flexible break time whenever the pedometer that she wears shows that she's walked 1.5 miles, or whenever she's been standing up to 1.5 hours. She's requesting no additional break time. She's also requesting to be assigned to the checkout aisle no more than 2 hours consecutively or 6 hours per total day. Is this employee afforded protection as an individual with a disability under the ADA? Under the old ADA, after the post-Toyota versus Williams, she would not be afforded protection because her condition, while limiting a major life activity, walking, did not prevent or severely restrict the individual from performing that activity. It was merely when she was performing in extremes of that activity, walking several miles a day or standing for several hours consecutively. Under the new ADA, or the ADAA, the individual might in fact be afforded protection because the ADAA specifically states that the EEOC and U.S. Supreme Court have incorrectly interpreted the term substantially limits to establish a greater degree of limitation than had been intended by Congress. The ADAA specifically requires an interpretation of substantially limits that puts at a lower threshold what substantially limits means. And they want it to be consistent with the original legislative intent. As was previously noted, the EEOC has not commented on that as yet, and this new definition has yet to be either derived or tested, but arguably this lower threshold may be met by the case that we discussed. Case 5. We have a 58-year-old otherwise healthy female with a long history of gout. She has symptomatic attacks a few times a year, which affect her lower extremity, requiring her to sit with the lower extremity elevated. She gets enough symptomatic relief from this to perform upper extremity tasks without limitation. She works as a cashier in a dollar-type store selling small objects. She and her physician have requested a sit-stand checkout station with a small footstool that she could use during her symptomatic periods, as this employee afforded protection as an individual under the ADA. Once again, we have a situation where under the old ADA, this individual would not be afforded protection. The condition was only intermittent and did not result in a permanent impairment. Under the new ADA or ADAA, she's extended protections because the ADAA extends protections to individuals with episodic impairments or with conditions that are in remission. If the impairment would substantially limit a major life activity such as walking in its active state. So in this instance, when she is symptomatic, and she can predictably become symptomatic in the future, it impairs walking, and therefore she is in fact afforded protection. Our next case, and we have a few actually related cases here, so we can move through them pretty quickly. 58-year-old otherwise healthy female, 1-year status post discectomy with normal strength, no residual sensory or reflex changes. Her range of motion is quantifiably limited with respect to forward flexion and with respect to extension. She continues to have some subjective discomfort at endpoints of forward flexion and predictably experiences discomfort when required to perform floor-to-waist lifting of certain weights and certain frequencies. She works as an assembler for a manufacturer of light machine parts. Her physician has requested that her workstation be placed on an adjustable height table and has suggested that it could be equipped with movable conveyors to equilibrate the height of her workstation with those around her. Is this employee afforded protection as an individual with a disability under the ADA? With respect to whether that accommodation itself is reasonable, the courts have consistently held that, particularly for large corporations and anything larger than a mom and pop, anything of that sort is probably going to be considered economically reasonable. However, under the old ADA, this individual would not be afforded protection because the condition did not substantially limit a major life activity. Under the new ADA, as was mentioned earlier, she might be afforded protection because, quote, bending, close quote, is specifically listed in the non-comprehensive, that is, including but not limited to, a list of major life activities. Peggy went through them in her talk, so I'll skip them, but because bending, and she has a quantitative limitation on bending, is listed as a major life activity, this individual would probably be afforded protection. Our next case, the saying 58-year-old otherwise healthy female, 2-year status post discectomy, normal everything, normal range of motion, normal strength, no residual sensory or dependent reflex defects. Her surgeon has kept her on a 45-pound lifting restrictions just on a precautionary basis. Recently, she was denied a promotion from an inside sales position to an outside sales position because her manager felt that her lifting restriction might be problematic with all the travel that might be involved in the position, either from carrying luggage or carrying samples, etc. She was successful in her ADAA claim as being regarded as disabled. And as part of her settlement, she was in fact given her regional sales representative position. She stated, though, that since her employer doesn't believe she can travel anyway, and since there are non-travel positions available, she would like to not have the one of the positions that require travel. And the question is this employer required to make this accommodation under the ADAA? The answer to this scenario is probably not, or maybe even no. The new ADA makes clear that there is no duty to provide reasonable accommodation to an individual who is considered disabled under the ADA or afforded protection purely under the regarded as or record of prongs definitions of disability. And this makes sense, and this was a long-standing sort of practice, but was not necessarily specifically stated. If somebody has a disability, then the expectation is that that disability will be reasonably accommodated. If someone does not have a disability, but merely has a history of a prior disability or is being somehow regarded as having a disability, then their contention is that they don't have one now, but they're being treated like they have one. So that individual would not have a basis to request an accommodation. So that makes sense, but this was the first time that this was actually put into black and white language. And our last case, which I'm going to move through very quickly, we have a 38-year-old otherwise healthy female. Once again, she's 1-year status post back surgery, normal strength, no residual sensory or dependent reflex deficits. Her range of motion is limited. Okay, so she is somebody who has restricted bending. She does have subjective discomfort, predictably experiences discomfort with frequency and weight of lifting, etc. So she does have restrictions in place. Recently, she received a same promotion from inside sales to outside sales. There are 2 types of outside sales position, ones which require frequent travel and therefore lifting, and others that do not. She specifically requested the non-traveling position, not related even necessarily. She's requested the non-sales or the non-travel outside sales position. A male counterpart, everything else being equal, same seniority, same performance evaluations, etc., was given the traveling sales position, which he did not prefer. The counterpart has raised a reverse discrimination suit under the ADAA based on the fact that he does not have a disability and he was denied a position that he would have otherwise had access to. Will his claim succeed? As we talked about, this will not succeed under the new ADA or the ADAA. There's a clarification that an individual with a disability cannot pursue a claim of reverse discrimination on the basis of not having a disability in the context of the Act. So that's actually one of the few sort of counterbalances to a lot of changes that actually seem to go against employers in the ADAA. That's all I have. I moved through the last few cases kind of quickly. If folks do have questions, please feel free to call or email me. And I think now we're going to move on to the sort of open Q&A portion, and Dr. Hartenbaum will take over here.
Okay, we have quite a number of questions. I'll actually we'll do the MOC questions first. First is, which of the following are considered major life activities under the ADA amendments? And Jim, do you want to give us the right answer for that one? Choices are brushing one's teeth, the ability to become pregnant, or normal gastrointestinal function, or all of the above. Jim?
I'm still here. I'm sorry. I apologize, Natalie. I had my line.
I'm sorry. You wanted to answer this one for us?
My line muted.
Okay. I'll go ahead and give the answer. The response is all of the above.
Correct.
And the next question. In determining whether an individual will be covered under the ADA after January 1st, 2009, mitigating factors should be considered. The response here is false.
Should not.
Should not be considered with the exception of corrective lenses.
Correct.
Normal corrective lenses. And the last question, employees who are disabled or regarded as disabled are entitled to reasonable accommodation. And Peg, I heard you on the phone.
Right, and people regarded as are not entitled to a reasonable accommodation, if that's the only category.
Okay, very good. Thank you. So we'll move on to the question and answer period. And the first question, interestingly, is a CDL question. If in performing a CDL medical exam or a firefighter exam under NFPA 1582, the examiner finds the individual not qualified due to a medical condition, are they now disabled, regarded as disabled, and what recourse does the individual have? Jim or Peg, either one?
Jim, I'm gonna defer to you on that.
I would say that in this context, as we mentioned, there is a specific deference in the Sutton triad of cases and subsequent cases, and the ADAA is silent with respect to public safety. So decisions made with respect to clearing somebody for commercial driving or to be a pilot or to be a firefighter, et cetera, where there's a public safety concern, those decisions will trump ADA or ADAA considerations. So the person is not being deemed as regarded as disabled by the employer. The employer is simply making a public safety determination.
The next question, Peg, this is for you. Please clarify regarded as. For example, if an employer proactively moves an employee, for example, diagnosed with cancer, but the employee has not requested special accommodations, can the employee then sue for discrimination? And effectively, must the employer wait for the employee to request?
Right. I mean, obviously we'll see how this shakes out with new case law, but for now, what I would suggest is I don't think you have to wait for the employee to ask for accommodation, but I also think you don't want to force an accommodation on somebody who says, I don't need this. And so the example had been a case where a supervisor just decided that an employee with cancer, that the job was too strenuous for that employee with cancer. That employee said they felt fine, and the supervisor moved them to a less strenuous position anyway. That, I believe, would set up a regarded as claim. Whereas if the employer just talked to the person to make sure that things were okay, to let them know accommodations are there if you need them, but doesn't force them into it, I don't think that they'd be giving them grounds for a lawsuit, even though maybe that suggests you regard them as disabled. I think that this regarded as prong is just really put employers in a particularly delicate situation, and it's going to be necessary that they tread very, very gently.
Thank you. And if you can also address the next couple of questions, which are in reference to a medical certification form. Can you give an example of a medical certification form or suggested wording that should be on one?
Right. I do not have one. I've never used one myself. I just know that I have some clients out there that do. I mean, something that might be a good idea to look to could be, sort of tracking what the FMLA healthcare provider certification, although that requires very little information. Jim, as somebody who's actually in a large corporation, do you folks have one that you've used?
Yeah, I just actually revised mine, and I'm trying to remember. I believe I found a couple of examples on the Internet and modified it from there.
And we have a couple of standardized forms that we use as well.
And examples of the questions that we have asked are, I'm trying to find my form. What is the accommodation you are requesting? Is it time sensitive? What limitations or conditions are interfering with the ability to do your job? What job function or tasks are you having difficulty performing? What benefit are you asking? How will the accommodation assist you? And then additional information. And then there's a second form that was going to the physician, again asking, does he have a physical or mental impairment? Be specific. Time frame, please describe how that impairment is a major life activity. Does it limit, and what are the functional limitations?
So I would say I don't hear anything that suggests that form needs to be revised. It's probably more in how the company deals with the information that it gets on that form.
Right. That is the new form. That actually is taking the old form and modifying it on the amendments. So the next question, and again, what I just really done was searched on the Internet for samples. Next question, I assume the regulations that the individual still be able to perform the essential job functions of their job with or without accommodations has not changed, or is this somehow reducing the employee's need to perform those essential job functions?
No, that has not changed. At least in theory, that's still the case. It's just that it's going to be much easier for the employee to make the case that they qualify under the statute.
The next couple of questions are a reference to medically necessary. Can the employer evaluate whether a requested accommodation is truly medically necessary, as employees occasionally make requests that are more personal convenience or lifestyle?
Yeah, at least my thought is that has not changed either, and that it still does have to be a reasonable accommodation that, in fact, addresses this impairment and is not just something that's totally a matter of convenience for an employee.
If a person has previously appealed to the EEOC in order to force an employer to provide accommodations but lost because of not being considered truly disabled, may they now reopen that appeal given the new definition?
Not unless a new decision gets made, because right now what it's saying is that if the action is based on a decision that was made prior to January 1, 2009, it's covered under the old ADA, not the ADAA. So unless something new happens and a new decision is made, then they should not be able to reopen that appeal.
Peg, are they able to, this is Jim actually asking a question, are they able to raise a new and perhaps derivative claim that may or may not be either directly related to their prior claim or even peripherally related, but frame it as a new claim?
That's right. If they do something that triggers the employer making a new decision, then I think that it's a whole new ballgame. And obviously, if they bring a claim, the employer will argue and raise some defenses, but I'm not confident that the employer wouldn't lose and find themselves operating under the new statute if, in fact, there's a decision that's made that triggers the new claim, and that decision's made after January 1.
Okay, next question is, does the fact that an employee is not compliant with their medical regimen and the effects he is experiencing solely are a result of his action? Previously, we had assumed that the employee and patient bears the burden of taking normal measures to control their disease. If they are non-compliant and therefore having problems, would that then put them in the disabled category?
I believe it will, because you can't look at mitigating measures anymore. And so if I were the plaintiff's lawyer in this case, I would argue, what difference does it make whether my person takes their medication or they don't, because if they did take the medication, you couldn't factor that in anyway. So I think that this is an area that's probably a big change.
Okay. A variant on case 3, Jim. What if an employee is in a safety-sensitive position but not one covered by federal regulation? For example, the company has a policy requiring a particular best corrected vision in a particular position, but there is no federal requirement to back that up. Would that individual then be covered or not covered?
The prior cases that we discussed all relied on specific federal regulations, I think, and I would defer to Peggy. In practice, as long as employers can solidly connect the dots to what the safety concern is, even if there's not a specific regulation that speaks to that. If the employer, has delivery car drivers that just drive in their personal cars, or they have salespeople that drive in their personal cars that are not covered by specific federal regulations, but it's a corporate safety regulation that can reasonably be related to public safety, I think it's a defensible position. Where folks get in trouble is where you cannot connect the dots to what the public safety concern is.
I agree with what Jim said.
Well, there's one side where it indicates that hearing aids are mitigating measures, but there was some.
I think that was a misunderstanding of what I said. A hearing aid is a mitigating measure, but you can't look at mitigating measures in determining whether the person is disabled. So even though the hearing aid enabled them to hear, they're still disabled, because now you can't look at mitigating measures.
Is there a financial limit on what constitutes a reasonable accommodation?
No.
Yeah,
I mean, at least on a specific bright line, it all goes back to the word reasonable. So what's reasonable for one employer in terms of dollars and cents might not be reasonable for another.
And
can we still require medical documentation as part of our reasonable accommodation request process?
We can require it. One of the things that we are always driving home within medical, though, is that it's best practice for that medical information to come into medical, maintain a firewall between medical and human resources and or operations, so that medical can say, yes, it seems like a reasonable request based on whatever the condition is, but it doesn't open up subsequent regarded as, et cetera, claims, or just other sorts of employment discrimination claims in the future.
Okay, as we're already kind of a bit over time, we'll do one final question, which is, as an employer that currently requires certain employees to obtain vaccinations in their offer letter, if the employee cannot obtain those immunizations, pregnancy, allergies, et cetera, do they have to be accommodated or can they be terminated?
I don't really think that winds up being an ADA issue. At least, well, I guess it would depend on the reason that they couldn't get the vaccination. Pregnancy would not typically be covered by the ADA. What was one of the other reasons?
Pregnancy, allergies.
Allergies, but allergies might be. I'm sort of leaning towards that they would have to accommodate that as long as it didn't pose a direct threat to others. What do you think, Jim?
Actually, as Peggy said, it's very context dependent, and in fact, I believe our medical center occupational health group looked at this earlier last year within ACOEM. Long and short of it, if the immunizations are required for the person's job duty based on public safety, which is what a lot of the hospitals do for nurses, et cetera, the argument there for the requirement of the immunization is based on public safety. The onus is on the employer if the person absolutely can't receive the immunizations if they have another job to place them in, to try to place them into another comparable job. That will be driven by the size of the employer. If, on the other hand, the immunizations are required, say, for executive travel overseas, it would probably be within the employee's purview to say, I'm allergic to these, I don't want to take them, and I'm willing to take this job and assume those risks. The employer can't require the employee to take the vaccines for international travel, but by the same token, they don't have to necessarily change the essential job functions of that executive position, no longer requiring international travel if it's a crucial part of the job.
And I just found we can go a couple minutes more. We do have a few more questions. To clarify the MOC question 3, the correct, I think there was an extra word there, but the correct answer is that employees who are regarded as are not entitled to reasonable accommodation. So take the word disabled out. Employees who are regarded as disabled are not entitled to reasonable accommodation. Another question is an individual who is actively abusing drugs or alcohol considered disabled under the ADAA 2008?
Yes to alcohol, no to drugs. That part of it hasn't changed. Unlawful drug use is not protected under the ADA, and the ADAA didn't change that. Alcoholism is protected. Now, that doesn't mean that you can't focus on the reasons for the poor performance. You just want to stay away from the discussion about why the person's performing badly. You're coming to work intoxicated, that's against rules, that's unacceptable, or you're slurring your words, or your reports are incoherent. All those things are perfectly fine, and you can discipline for them. Do not get into a discussion of go get yourself some help if you want to keep this job, because now you're focusing on alcoholism rather than job performance.
And this really will be the final question. Does anything change regarding restrictions involving imminent danger to themselves or others before applicable?
I saw nothing that changed that in theory, and I don't think that I don't think anything's going to change under that aspect. What do you think, Jim?
Yeah, that's the Chevron case, and I didn't see anything in the ADAA that specifically spoke to that.
Okay, then that'll be all for today. Thank you all for joining us, and have a good day.
Thank you.
Thanks, everybody.
Pleasure.
Thank you, ladies and gentlemen. This concludes today's conference. Thank you for participating. You may all disconnect.